Well, welcome, and welcome to everybody online. My name is Faith Van Horn. I'm an attorney with DNA People's Legal Services here in Flagstaff. And today we're going to be talking about Landlord-Tenant Law in Arizona. Okay, so this is the name of the Landlord-Tenant Law in Arizona. It's called the Arizona Residential Landlord and Tenant Act, and this is the abbreviation for it. So this law applies to rentals of dwelling units, and that's defined as a structure used as a home or a residence. So typically an apartment or a house. A lot of people live in mobile homes or trailers or things like that. That's not actually included under this law. They have their own separate landlord-tenant law for mobile homes, unless the tenant is renting the home and the lot from the same landlord, and it's all kind of a package deal. A lot of times people will own the home and rent the lot, or some combination of that. That's where the other mobile home landlord-tenant law would apply to that situation. It's very similar, but there are some important differences. So if you're in a mobile home, just be aware of that. This third bullet point here is the citation to the Arizona Residential Landlord and Tenant Act. So if you are looking in a law book, that's the way you would find the beginning of this law. Below down here are some of the situations that are not covered. They didn't list mobile home, I don't believe, but some of the other situations that are not covered by the Landlord-Tenant Act. So hotels, institutions, public housing. So if you live in public housing, if you have Section 8, those have their own federal regulations that they must follow, and any other sort of federally regulated, federally subsidized housing would have that. Okay, so I mentioned there are other landlord-tenant laws in Arizona. The Arizona Mobile Home Parks and Residential Landlord-Tenant Act applies to mobile homes, and this is the citation for that. That's where you would find that law. And then RVs have another law that applies to them, the Recreational Vehicle Long-Term Rental Space Act. And I have the citation for that there as well. Both of those laws kind of define what's included in them, so it will say what they mean by a mobile home, what they mean by an RV, what the requirements are for this law to apply to your situation. And then, as I mentioned, public housing, other federal housing has its own regulations that it needs to follow. Okay, so one of the most important things that we talk about in landlord-tenant law is communication between the parties. So whether you're a landlord or a tenant, it's very important to have good communication with the other party. We always tell people, always get everything in writing as much as you can. So landlords, if you need to give a notice to somebody about something that's happening, a lot of times the law requires it to be in writing, so in those situations you would have to do that. The reason for having, I'm saying to put things in writing so you have a record. So an email or a text message, that creates a record of who said what and when it happened. So a lease should definitely be in writing. Just because you don't have a lease in writing does not mean that you don't have a landlord-tenant situation. Sometimes there is no lease in writing and there's just an agreement where the tenant will pay every month and the landlord allows them to live there and provides maintenance. That's still probably a landlord-tenant agreement, but you don't have the benefit of the lease, which lists all the rules, everybody's responsibilities. It's definitely better to have a lease. Tenants, you should do requests for repairs in writing. This way you know exactly when you ask the landlord for something to be repaired. Notices, as I said, that's generally the landlord to the tenant, but the tenant sometimes needs to give the landlord a notice, such as when they move out. That should be in writing as well. And as I mentioned, this protects both parties, so everybody knows what's happened when, who's asked for what, and you have a record in case there's a disagreement later on. Okay, so we are just going to kind of walk through the whole process of a landlord-tenant relationship and how that typically works. So the first step after the tenant agrees to rent the property, the landlord agrees to rent it to that tenant, is the move-in process. So as I said, you should sign a written lease. You don't have to, but you should. It's much better, much more secure for both parties. If things go to court, you have something to kind of stand on there if you have a lease. Both parties need to sign it, the landlord and the tenant, and both the landlord and the tenant need to have a copy with the signatures on it. The lease should include some of these things. You can definitely have other things in the lease. There are some limitations in the Landlord-Tenant Law that say that what can't be included in the lease. So landlords, if you're working on getting a lease for your property, you need to make sure that you're following the law and you don't include things in there that are prohibited by the law. So some important things: name of the landlord, name of the tenant, the name of the property manager, if there is one for an apartment complex, or if the landlord's using some sort of agent to manage the property, that needs to be identified there. The address of the property that is being rented. You need to have the amount of rent and when it's due, so that everybody's clear on that. The amount of the security deposit should also be listed in the lease. And the law says that landlords are not permitted to charge more than 1.5 times the monthly rent. So if the rent is $1,000 a month, the most the landlord could charge for security deposit would be $1,500. It should say in there who is paying for utilities and which utilities. If it's split between the landlord and the tenant, it should say who pays for what. And then any other rules that the landlord has for the property. Again, landlords, make sure that you look at the Landlord-Tenant Act and you're not including something that's prohibited by the law. But one example is a pet policy. If you have rules about what pets are allowed on the property, that should be in there. Okay. So when the tenants go to actually move in, ideally, the landlord and the tenant should do a move-in walkthrough of the unit together. It doesn't always happen that they do it together. Sometimes the landlord will give the tenant a checklist, and the tenant will walk through the unit on their own and mark off damage, and then there'll be a due date by which they have to return that to the landlord. But there should be some move-in walkthrough done of the unit, marking things off that are damaged at the time the tenant moves in. The tenant should sign off on it, the landlord should sign off on it, and both should have a copy of that. You can also take pictures, if you're the tenant, of anything that's broken in there to kind of have something more specific about how something was damaged, or which, if it's a window, which one it is. You just want to document all of that in the beginning. And the reason for that is because when the tenant moves out and the landlord comes back in and finds damage, if you have this checklist, the landlord knows what damage was already there and what's new. And they can only charge the tenant for damage the tenant caused, not for damage that was already there when the tenant moved in. There are a lot of disputes that come up about that. We see a lot of those in our office, so one way to avoid that is to do this checklist in the beginning. That way you have some documentation of what the condition of the apartment or the house was when the tenant moved in. Okay, maintenance is another issue that often comes up while the tenant is living there. Both landlords and tenants have responsibilities under the Landlord-Tenant Law for maintenance. I should also say that sometimes landlords will have extra requirements of the tenant in the lease. Again, there's limits on what the landlord can require the tenant to do in terms of maintenance. Sometimes yard maintenance may be an agreement that the tenant's going to do yard maintenance, but the law here just states the responsibilities that the landlord always has and the tenant always has. And this is just a list of some of the things. So for the landlord, Generally, they have to keep the unit fit and habitable, which means it has to be safe, things have to work, they have to make repairs, maintain services like plumbing and electricity. If there's a common area, so if you live in an apartment complex and there's a lobby or there's a shared stairwell, that's the landlord's responsibility to keep that clean and safe. All of the requirements are listed in this section for the landlord. So if you're a landlord, take a look at that, make sure you know what your responsibilities are. Tenants, some of tenant responsibilities are generally keeping the unit clean, taking out the trash, not disturbing their neighbors. And then this last one's very important, promptly notifying the landlord of any damage that needs to be repaired. So tenant, if something breaks, if you break something, you need to let the landlord know right away so that they can take care of it. If it's something that you're going to be responsible for as a tenant, you still need to let them know that you've broken something. And again, all the requirements for the tenants in the law are listed here. So tenants, be aware of these things that are your responsibility. All right, so we talked about maintenance, and we talked about doing things in writing, including requests for repairs. So I want to talk about that a little bit more, in more detail. So tenants, again, make sure that you make requests for repairs in writing. This is important so that you know what you asked for and when you asked for it, and that the landlord, if you call the landlord on the phone, they may forget or it may get, pushed off to the side. You want to make sure you have something in writing. If it's an emergency, of course, you can call the landlord and say, my apartment is, something's flooding or leaking. Definitely make phone calls for that, follow up in writing, but you always want to have something in writing as well. Sometimes landlords don't do their job and they don't respond to the requests for repairs. Even if they're required to make those repairs under the law, sometimes landlords will just not do it and think they can get away with that. So if that happens, tenant, you have some options. They're not always great options, but one option, if the landlord's ignoring your request for repair for something that they're required to do under the law. So that's very important, not just something really minor, like cosmetic things. But if it's something major, the landlord's ignoring your request or they're refusing to do it, the tenant can give the landlord a notice saying, if you don't fix this problem within 10 days, I'm going to end my lease and move out. And it's 5 days if it's something that materially affects health or safety. So you could do a 5-day notice instead of 10. Like I said, it doesn't apply really to minor problems. It's only for things that the landlord's required to do under the law. So if you have something really little that breaks, like you have a mailbox that has a flag on it and the flag breaks off, you probably can't break your lease for that, and it's not a good idea to try that. It's just these things they're required to do, which are mostly to do with safety and health. So think about that. This is, if you do this incorrectly, it can end badly for you as a tenant. So if you're a tenant and you're having this issue with your landlord and you are interested in this option of ending your lease because of that, I would advise you to talk to an attorney before you do that, to make sure that this is the kind of situation where you can do that and that you do the paperwork correctly and the notices correctly. This is a question we get a lot as well. Can tenants withhold rent if the landlord doesn't make repairs? In Arizona, the answer is almost never. So you can in a few complicated situations. But for the most part, tenants cannot withhold their rent. Even if something's damaged, even if the landlord isn't making the repairs that they're required to make, the tenant still has to pay the rent. And if you're a tenant and that's your situation and you don't pay the rent, the landlord could evict you. So if you want to withhold your rent for some reason, you need to talk to an attorney before you do that. Otherwise, you risk being evicted for not paying your rent. All right, so There are several ways that a lease can end. One simple way is ending it early by agreement. So if the tenant wants to move before the end of the lease and the landlord is agreeable to that, the two can make an agreement for the lease to be done. So if you have a year-long lease and you're the tenant and you're 3 months in and you want to move out for whatever reason and the landlord agrees to let you go without charging you or whatever agreement you come to, you can do that. Again, do this in writing. This needs to be in writing. It needs to be signed by both parties. Another way the lease can end is just non-renewal at the end of the lease term. So most leases are for a year, sometimes they're for 6 months, sometimes they're for more. It can be for whatever period the parties want, but so for the purposes of an example, we'll say it's a year-long lease. At the end of that year, if the landlord does not want to continue renting the unit to that tenant, they don't have to do that. They can give the tenant a notice saying that they're not renewing the lease and the tenant will need to move out at the end of the term. The landlord does not need to give the tenant a reason for this. A lot of people will be kind of confused by that and think that the landlord needs a reason to not renew their lease. They don't. So if that's something to be aware of, if you're a tenant, your landlord could decide not to renew and at the end of any term if they want. The landlord does need to give the tenant proper notice that the lease will not be renewed. So usually that's 30 days. Some leases will require 60 days notice if the landlord doesn't want to renew. So like I said, the landlord does not have to have a reason not to renew the lease, but they can't refuse to renew for retaliation. So if the tenant is asserting certain rights under the law and the landlord then tells them, oh, I'm not renewing your lease, that could be considered retaliation. It depends on the situation. It can be very difficult for a tenant to prove that the reason the landlord didn't renew is in retaliation. So tenants, keep that in mind. That can be hard to prove. And it's only for certain rights that the tenant asserts. And they're listed in this section here, this 33-1381. At the end of the lease term, the tenant can also decide to move out. So once the lease contract is ending, so if it's for a year, at the end of that year, if the tenant wants to leave, they can do so. They also need to give the landlord notice that they're planning to move out. And it would be the same notice as what the landlord would be required to give them. Usually 30 days, sometimes 60. It depends on the lease. So make sure to look at your lease. I say here that the landlord must give the tenant enough notice that the lease is ending, that it's not being renewed, or the tenant can take the landlord to court. The same would be true if the tenant didn't give enough notice. The landlord could charge the tenant for another month's rent potentially, could take them to court for that fee. So tenants, there could be repercussions for you if you don't give enough notice. So make sure you know what you're required to do there. Non-payment of rent is a way that the lease could end partway through the term. So if at any point the tenant doesn't pay rent, the landlord has an option to evict the tenant for that. And what the landlord needs to do is give the tenant a 5-day written notice that says, you failed to pay your rent, this is the amount you owe, which would be whatever rental amount they owe, including late fees, and tell the tenant that they have 5 days that they need to either pay that rent, or often they can move out and end the lease. If the tenant pays the full amount that they owe to the landlord, then everything's okay. They get to stay. They've paid up what they owe. If the tenant does not pay and stays in the unit past that 5 days, then the landlord can go to court and file a complaint for eviction against the tenant. And that's when the eviction process will start. There'll be a hearing, probably about a week later. Sometimes it's less than that. The hearings are scheduled very quickly. And then the judge will issue an order either in favor of the landlord or the tenant. Another way that the lease can end is if there's a breach of the lease, and what that means is that a party has broken the lease. So if the tenant breaks the lease, the landlord can evict them for that. For this, the landlord needs to give the tenant a 10-day notice, and that notice needs to say what the tenant has done to break the lease, which part of the lease they've broken, so whichever section it is that they broke, what action they took that broke that section, and that they have 10 days to resolve the problem or the lease will end. So if the tenant solves the problem, they get to stay. Again, this timeline can be shorter if it's something that is materially affecting health or safety. It could be a shorter timeline. If the tenant does something that's an irreparable breach, which means that there is no way they can fix it, they, in some circumstances, can be immediately evicted. And that's generally if there's some sort of very serious crime that the tenant commits on the property. That could be a much quicker process. So, for example, here, if the tenant has a dog and the lease says no pets, and the landlord finds out the tenant has a dog, landlord can give the tenant a 10-day notice and say, you've broken the pet policy by having a dog in your apartment. You need to resolve this in 10 days or your lease will end. And then if the tenant gives the dog to their brother, it's no longer in the apartment, they tell the landlord, hey, the dog's gone, everything's good, the tenant would get to stay and the lease would continue. If the same problem happens a second time, the landlord has to give the tenant another 10-day notice, but this time the tenant does not get a chance to fix it. The landlord, landlords have some discretion there if they decide they want to be generous with the tenant and give them another chance. That's an option they have, but they are not required to the second time. So if that tenant gets another dog or gets a cat, they're breaking the pet policy again. The landlord can say, that's it. You've done the same thing twice. You have 10 days to move out, or else you will be evicted. In any of these situations, if the tenant stays past the end of the lease, the landlord can go to court and file a complaint for them to be evicted. Okay, so at the end of the lease, the tenant moves out. Like at the beginning, do a move out walkthrough. So you should use the same form, walk through the unit, mark off any of the damage that's there at the end. And then the landlord and tenant can compare those two checklists and see what damage is new. Tenants, you have a right to be present to do a move out walkthrough. So the landlord will do that once the tenant has moved out to see the condition of the unit. The tenant has a right to be there if they would like to, but tenants, you need to notify your landlord that you want to be there. So when you move out, you need to give them notice that you're moving. At the same time, you can tell them, I would like to be present for the move out walkthrough. Do it in writing. I would say to do it at the same time as you do your notice that you're moving out. And then tenant, if you do that, bring a copy of your move-in checklist with you so you can show the landlord in case the landlord's lost the copy or doesn't have it with him or her. You can bring that copy with you. Tenants should clean the unit before they move out. Often the lease will say what cleaning a tenant is required to do. One that we see a lot is like carpet cleaning, which is a bigger one. So tenants, you should do that. If you don't, that could be deducted from your security deposit. So sometimes for tenants, it's worth it to them to not go through the hassle of hiring somebody to do carpet cleaning if that's required, and they'll just let the landlord deduct it from your security deposit. Just be aware that that's the way that would work, that you will pay for it in some way if you're required to do it. And also make sure you remove all your personal belongings from the unit when you leave. If a tenant abandons the property, the landlord has certain responsibilities. And these are a couple different situations where a tenant could abandon the property. So the first one is the tenant is evicted. This is the writ of restitution at the end of the court process where they are physically removed. In that situation, this is the rule here. This section of the law tells the landlord what they need to do with the tenant's belongings. So landlord, if that's your situation, make sure you take a look at this and follow what you need to do. Otherwise, the tenant could take you to court if you're not following this correctly. If the tenant abandons the unit during the lease term, so they just disappear, stop paying rent, they're gone, but they've left things there, this section here, 1370, tells the landlord what you need to do in that situation. They're similar, there's a couple minor differences, but those are what you need to look at. So security deposits, I've mentioned already. This is something that we see a lot of disputes over as well. So it's important to make sure that landlords and tenants, you're following the right steps for these. The lease should say how much the deposit is and what it can be used for. And that will help clarify for both parties what can be deducted from there. After the tenant moves out, the landlord has 14 business days to send the tenant back their security deposit. So that's business days, not counting weekends, not counting holidays. It ends up being almost 3 weeks, not quite. So it is a significant amount of time for the landlord to get that money back to the tenant. Tenants, you need to request your security deposit back in writing. So the law says that the landlord has 14 days from the time the tenancy ends, the tenant vacates the unit, and demands their deposit back. So tenants, just make sure you ask the landlord for your money back. And you can do that, again, when you're moving out, when you return the keys, you can give them a notice and say, please return my security deposit, and here's my new mailing address. And it's very important that you give them a new mailing address so that they have somewhere to send that money to. So landlords, the security deposit is for you to make repairs to the unit within the confines of what the law says you're allowed to use that for. So landlords are permitted to keep some or all of the security deposit if they can justify why they did so. So landlords, you have 14 business days to figure out what needs to be repaired, make those repairs, and you need, if you keep any of the security deposit back from the tenant, you need to write out an itemized list of what you spent that money on and send that list to the tenant. So if you keep all of their deposit, if you can justify it, that's okay. You need to send them an itemized list showing what you spent, what repairs you did, how much each was. If you keep some of the money, again, send the list showing what you spent and send them back the rest of the money. And then landlords, I would say you should keep receipts for work that you do, because the tenant does have a right to dispute your charges. So tenants, 14 business days, somewhere in that time frame, you get your itemized list from the landlord. So if they don't send you back all your money, you get an itemized list saying what they spent it on. If you disagree with what they spent it on, or you think they were repairing things that weren't broken, or spending money on things they shouldn't have been, or you think that the cost is way too high, anything like that, you have 60 days to dispute those costs. Otherwise, they become final. The law isn't clear exactly when the 60 days start, so I would go with the date that the tenant or that the landlord's letter is dated. So that way you know your 60 days from when they put that letter in the mail to you. But it's better to do it sooner rather than later to be sure you don't miss that timeline. So if you dispute their charges, tenants, you should write a letter to the landlord. You can handwrite it, mail it to them. You should do certified mail so that you know you get a record that they received it, and you have that proof if you have to go to court later of the date that it was received by the landlord. You could also hand deliver it. If you do that, make sure that you know it was hand delivered and what date it was hand delivered on. After the tenant sends this dispute letter, if the problem isn't resolved, then the landlord or the tenant can take the other party to court. So sometimes tenants very severely damage an apartment or a house, and the tenant actually owes the landlord money on top of the security deposit for all the repairs, the landlord can take the tenant to court to get that money. And tenants, if you think the landlord kept too much of your money, you have the option to go to court to ask the court to order the landlord to give you that money back. Okay, so that's all I have